Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm Attorney John Redmann.
Hello everyone, I'm Shauna Sanford. Welcome to the show. Well, have you noticed the number of insurance commercials on television? They are hard to ignore. Insurance is something that we all have to have, from covering our homes, businesses, cars, and the list just goes on and on. But what happens when you file a claim and it's not thoroughly investigated? What if the insurance company refuses to settle your case or shortchanges your benefits? You do have options, one of which is to file a lawsuit against your insurance company for bad faith. Now, if that's not something you're familiar with, then stay tuned, because our guest today is going to walk us through some of the important things that we all need to know about how to handle issues of bad faith when it comes to insurance companies.
This is an important topic, and one that I have encountered on many occasions. In a nutshell, insurance bad faith claims happen when an insurance policyholder feels that his or her insurance company didn't act with his or her best interests in mind. This issue comes up quite often. Today, we have an excellent attorney to walk us through this topic. Attorney Dean Sutherland will join us for a two-part series on insurance bad faith claims.
And I'm really looking forward to this, because this is a big problem within the insurance company. And folks here in Louisiana know a lot about dealing with insurance companies. Tell us a little bit about your experience of dealing with this whole issue.
Sure. You know, the prime example, and I think where America's, let me say, the Louisianians' innocence on this topic was probably lost after Katrina. Many homeowners came to me and they said, I had no idea an insurance company could treat me poorly. When homeowners' claims, when the roof was blown off their house, insurance companies routinely, in their experience, and my own client's experience, said, you know what, we blame this on flood. And on behalf of many of my clients, I had to sue insurance companies, not only for what the insurance company owed them for their claims, when we believed that they owed them a lot of money for their insurance claims on their homes, but for bad faith in addition, which is penalties under the laws. And it applies in car accident claims too. We'll get into that with Dean Sutherland shortly.
Okay, all right. And for people who are afraid out there to fight the big bad insurance companies, they do have options. We're going to find out about those coming up next. Attorney Dean Sutherland joins us to talk about what you can do if you think your insurance company is not treating you fairly after you have filed a claim. Stay tuned. We'll be right back. Hello, everybody. Welcome back to the show. Well, today's topic is sure to hit a nerve with many of you watching. Let's say you've been with the same insurance company for several years. You had to file a claim, and it looked like things were going well, but now you're getting the runaround. You can't get any help, and you feel that you're being treated unfairly. Well, we're excited to welcome Attorney Dean Sutherland to Power of Attorney, because today Dean will actually he'll be with us for 2 episodes to help us better understand what sort of recourse we have when insurance companies act in bad faith. John.
Dean has been practicing for almost 4 decades and has taught at both Loyola and LSU law centers. He has also written numerous articles and given countless lectures about insurance bad faith. He currently practices insurance law at the firm of Johnson and Redmann. Dean is one of the people that we look to help us talk about this very interesting topic. And I've enjoyed your article on insurance bad faith, and because I practice in the area of insurance law representing mostly plaintiff, and your practice is involving defense, I think we'll have a great discussion. But why don't we do this? If you would define for our guest, what is insurance bad faith? Let's start with the description.
Sure. There are 2 sources of law on insurance bad faith. One is what the judges say in deciding cases, and there are 2 specific laws that the legislature has passed. Broadly, every insurance company has a duty to act in good faith to both people that they insure and third-party claimants. And that's in the law that the judges have made up. It's also in one of the 2 laws that the legislature passed. But the fun part is, in the 2 statutes that the legislature passed, they don't use the word bad faith.
That's a very good point. In other words, bad faith is a word that the lawyers use with one another, and when dealing with insurance adjusters, when they're trying to get the insurance adjusters, well, for instance, if I'm representing somebody who has an insurance claim, they got injured or they have a homeowner claim, for instance, we say, you're not offering enough. In fact, I think it's such a bad deal, or you're so late in offering to pay, that's bad faith. And one other thing, third-party claimants. Why don't you define what is a third-party claimant? Third-party claim.
Yeah, third-party claim. A first-party claim is where you're suing your own insurance company for a benefit to which you're entitled under that policy. A third-party claim is where someone who's not insured under that policy has a claim against the person who is insured under that policy. And so the third-party claimant is bringing a claim against someone who's insured for their liability, for example, to a third party.
I think it's really great to know that there are both state and federal laws when it comes to this issue of bad faith, and it is a serious problem. Give us some example or give us some idea of just how widespread this issue is for people.
Well, anytime an insurance company doesn't properly handle an insured claim, you can have a potential bad faith claim.
Mm-hmm. So it keeps you pretty busy, huh?
Yeah.
And in fairness, a lot of times people think that the insurance company didn't pay them fairly or pay them promptly. They have good reasons not to pay. For instance, the other driver who is accused of having caused the accident says, well, it wasn't my fault. I had the green light, and the other person who says they were hurt had the green light. And so the insurance company is not obligated to pay if they have a good excuse or argument why they might not be responsible for paying. That might be one example, right?
Sure. That's on liability claims, on third-party claims. You can have it under first-party claims. Normally, first-party insurance is without fault. Mm-hmm. It covers your homeowners. You buy insurance for your house unless you intentionally set your house on fire. If your house accidentally catches on fire, then your homeowners will pay to rebuild your house.
Yeah. And you know, I'm glad you mentioned that in this episode, and we're doing this is such an important topic. We're going to cover this in 2 episodes. Today's episode is about first-party claims.
Right.
And so let's talk about let's define what are the most typical first-party claims that affect most people. Yeah. Let's do that, and then let's get into some examples and go into that further.
Okay. You mentioned earlier the big ones, but it could be health insurance, although that's got a couple of caveats on that. Mm-hmm. But your homeowner's policy, your first party coverage for your car for collision and comprehensive damages, uninsured motorist coverage. Those are the big ones that I can think of.
Yeah. So, and I want to go back to
life insurance, but that's treated differently too. I'm so sorry, Shauna.
Yeah. No problem. No problem. And you did mention workman's comp, right?
I have not yet, but workers' comp is different.
Right. And we want to be very clear about that
yes.
to our viewers.
Yes, workers' comp is its law unto itself. It's in a different part of the Louisiana statutes, and it's just they have some elements that overlap, but you really do need to talk to someone who knows workers' comp if you have a workers' comp issue.
If I may add to that, that's not what we're going to get into in this show, but there is something where under workers' compensation, if you get injured and you're owed workers' comp wages, workers' comp medical treatment because you got injured on the job, if you don't receive those benefits, the insurer or the workers' comp insurer can be found in bad faith for being arbitrary and capricious in not paying. But just for today's show, the recommendation is you call a workers' comp attorney, get a free consultation, and if, number one, you want to make sure you get the benefits you're entitled to, medical benefits, wage benefits, and you may have a very good case to show that they're in bad faith if they don't pay what they're supposed to pay. But for today's purposes, we're going to focus on things outside of workers' compensation, as you've just outlined, basically.
Yeah, and I think this is something that you mentioned earlier, but just for our viewers, so that we can be very, very clear about this. Just because an insurance company denies a claim doesn't mean that it's an issue of bad faith, right? I mean,
absolutely.
So help us to understand what really constitutes bad faith.
The insurance company has certain definite obligations All right, but they're all triggered. The statutory obligations are triggered by the person who's bringing the claim filing a satisfactory proof of loss.
Okay.
So the very first thing that has to be done is, if you have a claim against your insurance company, you've got to file a proof of loss with that insurance company to let them know that you have a claim that comes under their insurance policy.
Okay.
Then their obligations trigger it.
Yeah, and just even to take a step back, and I think a really good example for much of our viewing audience is, a good example is the Katrina experience. Many people were away from their homes, but by watching CNN, they knew that their house had been impacted by high winds and flood. And if you had a homeowner's policy, which was winds and wind-driven rain, if you knew you had floods that also impacted your home, hopefully you had a flood policy. Even if you weren't home, you would give notice to your insurance company. You'd call them, you'd send them an email and say, my home has been impacted by the storm. I don't know how much, but you want to first give notice to the insurance company and say, hopefully, let's as soon as you can, get an adjuster out there. Hopefully you can meet the adjuster, let the adjuster step foot on the property to start to assess the damage. So notice starts a time clock ticking, because suddenly you're out of the house and you need money to get shelter and clothing and what's called ALE, additional living expenses. Why don't you talk about that?
Most homeowners' policies have an ALE provision that provides an amount to cover you if you can't be in your insured residence during the period of time that you're unable to live there. And it generally covers reasonable food, water, hotel room if you need that, transportation if your car's got wiped out. But it's the additional living expenses that a person who's insured by a policy has to incur in order to live till the house gets fixed.
Right.
And so we want to be very clear to our viewers as well. You mentioned that the state laws, doesn't actually contain the phrase bad faith. But so in your policy, you're not going to find that phrase in your policy either, right?
No.
It's not there.
No, the obligations are from the laws. The statutory language is arbitrary, capricious, or without probable cause.
Okay.
A lot of lawyers think it's an and, but it's an or. But what our Supreme Court, in interpreting what the legislature meant by that, basically it means unreasonable.
Anything that's unreasonable.
Yeah, and it's like, well, they use the word vexatious, because I guess Supreme Court justices like to use big words, but it really means you don't have a good faith basis for denying the claim, that you have everything you need, that you should do it, and there's just no rational, reasonable basis not to pay.
So at what point do you tell clients that, or when you're talking to potential clients, this is the point where a line has been crossed and now it's time to take action, legal action?
One of the two Louisiana laws in particular lays, well, actually both of them do, and they put out different obligations on the insurance companies. So, for example, an insurance company has a duty, once they have notice of a claim, to investigate. And if they don't, then they're violating the statute for more than 30 days after they get a proof of loss.
Okay, well, we're going to hold it at that point right there, because we do have to take a break, and that's something that I mentioned earlier. If you feel like your claim hasn't been thoroughly investigated, so what constitutes a thorough investigation? How long should that take? There are probably a lot of people out there who are in that similar situation or have friends and relatives who've been in that situation, and so that's a very important question that we're going to get you to answer as soon as we come back from the break. Coming up next, also, we're going to include you in on this conversation. We're going to get to your questions with our guest today, attorney Dean Sutherland. So be sure to stay with us. We'll be right back after the break.